started. I am delighted to introduce our speaker, Judge Colette Rutel. She is a judge in Hennepin County, and I will go ahead and turn it over to her.
Okay, good afternoon, everyone. Thank you very much for inviting me to speak here today. Obviously, I was appointed as a judge in Hennepin County by Governor Walz last fall, but before that, for those of you who know that I was a professor at Mitchell Hamlin School of Law, and my main area of expertise was federal Indian law in particular. One of the subjects we're talking about today, which is civil jurisdiction in Indian country. And so I was approached to give this CLE because apparently at a bunch of other CLEs that have been offered through this program, there have been a lot of questions about basics of civil jurisdiction in Indian country. So I'm going to do my best to run through that in about an hour. To the extent that you do have questions, specific questions, feel free to put them in the chat. I'd much prefer to respond to those than to run through a bunch of PowerPoint slides. But I will go ahead and get started if my screen works. So first, I want to talk with you a little bit about the conceptual framework to figure out the question that you need to ask yourself when you're trying to figure out who has jurisdiction in Indian country. So you need to figure out the who and the where, because both of those things matter. And so when I mean the who, first I'm going to start off with who are we talking about exercising jurisdiction? That is, what sovereign? And it could be more than one sovereign. You could be trying to figure out which sovereign or sovereigns can exercise jurisdiction. So are we talking about the federal government, state government, or tribal governments? And yes, Indian tribes are governments, and there are more than 500 federally recognized tribes in the United States, including many here in the state of Minnesota. In addition, one of the initial things that you'll have to ask yourself is what type of jurisdiction are we talking about? Are we talking about criminal jurisdiction? And that's a different presentation. I'm happy to answer your questions on that, but we're going to focus here today on civil jurisdiction. And there are two types that we usually divide civil jurisdiction into. In Indian law, civil adjudicatory jurisdiction, so hearing a court case, or civil regulatory jurisdiction, applying the laws of that particular federal, state, or tribal government. So it's important you start off trying to figure out which sovereign and then which type of jurisdiction you're talking about. And then you also need to figure out who is involved in either the court case if it's civil adjudicatory, or who is the government attempting to regulate if it's civil regulatory jurisdiction. And in Indian law, we usually use these three terms, and they're not necessarily common sense based. So I want to explain what they mean. When we talk about a member, we're talking about a citizen of a federally recognized Indian tribe, and not just any federally recognized Indian tribe, the tribe whose reservation the activity we're talking about is occurring on. So, for example, if you're hanging out playing slots at the Mystic Lake Casino, that's on the Shakopee Mdewakanton Sioux community's reservation. If you are a member of the Shakopee Mdewakanton Sioux tribe, then we would consider you to be a member Indian for the purposes of our analysis today in civil jurisdiction. But there's also this category of non-member Indians, and it's not really what it sounds like. You are still a member of a federally recognized tribe, just a different tribe than whose reservation you're on at that moment. So again, if you're playing slots at Mystic Lake, but you're a member of the Mille Lacs Band of Ojibwe here in Minnesota, you would be considered a non-member Indian for the purposes of our civil jurisdiction analysis. And then we use the category, we talk about non-Indians, and that doesn't mean that you don't identify as being Native or that you don't have Native ancestry. It just means that you're not an enrolled citizen of any federally recognized tribe. So you're neither considered a member Indian or a non-member Indian for the purposes of our discussion. So it's a little bit complicated trying to figure out the who, but you need to for jurisdictional purposes, and we'll see why in a little bit. And then we also need to talk about where. The special rules that are involved in federal Indian law apply for the most part only within Indian country. And so federal statute 18 USC 1151 specifically delineates 3 different areas as part of Indian country. All land within the boundaries of a reservation, all dependent communities, and all allotments if the trust title to the allotment has not been extinguished. So this can get a little bit complicated, and for anybody who has followed the U.S. Supreme Court's decision in McGirt versus Oklahoma, you understand why this is important. I'm giving you 2 examples. If you have a reservation, like on the right-hand side of the screen, within reservation boundaries, the land ownership could be owned by non-Indians, by the tribe itself, by tribal members, and it could be in fee simple or what we refer to as trust. So it could be held by the United States in trust for the benefit of a tribe or a tribal member, and we would call that trust land. Within the boundaries of an Indian reservation, all of that, no matter how the property is owned, that's all considered Indian country. And so the special rules that we're going to talk about apply. If the reservation boundary doesn't exist, then the only land that is considered Indian country is going to be trust land, because that's the land that is either going to be, on this previous slide, considered a dependent community or an allotment. And so this talk isn't about McGirt. I've given a lot of talks about McGirt in the past, but this just gives you an idea if the reservation boundary is present, like the Supreme Court decided it was for the Creek Nation in McGirt versus Oklahoma. The area within which these special Indian law rules apply is greatly expanded. And for most of us here in Minnesota, there was a recent federal court decision recognizing the boundaries, the exterior boundaries, the Mille Lacs Band's reservation. And so Mille Lacs Band reservation, you can picture that on the right-hand side of the screen, includes all land within that reservation boundary, regardless of how it's held. Okay, so those you can see already, we've got a lot of precursors we have to figure out before we even start talking about what the rules are. We're asking which jurisdiction is going to attempt to apply their laws. Is it federal, state, or tribal? We're asking who they're going to be applied to. Is it a tribal member, a member of a different federally recognized tribe, or a non-Indian? And then where are we talking about, within Indian country or outside of Indian country? So I want to start off now, and that we walk through those preliminary discussions with what is tribal civil jurisdiction, either regulatory or adjudicatory, like in Indian country. And so first, I'm going to say this a couple times in this presentation. A lot of people know something about this federal statute called Public Law 280, which was passed in the early 1950s. And it is important for civil jurisdiction, but it's only important for one category of civil jurisdiction, and that is the state's ability to hear court cases that arise on an Indian reservation in the state. It has nothing to do with tribal jurisdiction. And we'll see it also has nothing to do with the state's ability to exercise regulatory jurisdiction. So I'm going to start off by saying, if you know something about Public Law 280, it doesn't affect this analysis. It does not affect the scope of tribes' sovereignty. So when you're talking about, does the tribe have power? The most important piece is the identity of the defendant when it comes to civil adjudicatory jurisdiction. So you have a plaintiff and a defendant involved in a court case. The identity of the defendant is what matters for civil adjudicatory jurisdiction, whether the tribe has jurisdiction or not. And if we're talking about regulatory jurisdiction, the tribe wants to apply its laws to someone, that we look and see who are they trying to apply the law to. Is it a member? Is it a non-member Indian? Or is it a non-Indian? And there are different rules that apply based on that. The tribe always has the authority to hear court cases or to apply its civil regulatory laws within Indian country to its own tribal members. That's part of inherent tribal sovereignty. So what that means is, if you want to bring a lawsuit against a tribal member, let's say a member of the Mille Lacs Band of Ojibwe, you can always bring that lawsuit in Mille Lacs Band tribal court, and the tribal court will always have jurisdiction to hear that. It is part of the tribe's inherent sovereignty. And that's true regardless of who the plaintiff is, whether they're a tribal member or not a tribal member. right? And if the Mille Lacs Band of Ojibwe passes a law about zoning, for example, within the Mille Lacs Band reservation, that law is going to apply to land within the reservation that's owned by a Mille Lacs Band tribal member, because the tribe has the authority to regulate conduct by its own tribal members within Indian country. So that's the easy part of this analysis. Things get a little bit more complicated if the person involved is non-Indian. And remember, we've defined this not as somebody, the person could be somebody who identifies personally as being Native, but they're not an enrolled citizen of any federally recognized tribe. And so if the defendant is non-Indian, we have to add another preliminary question here and ask, what land does the lawsuit arise on? So it's within Indian country, but we still might have to figure out the land status. Is it on fee land owned by a non-Indian or its equivalent? So if, for example, does this take place on a state highway? So is there a state right-of-way or easement? In those cases, if the defendant in a civil lawsuit is a non-Indian and the activity that created the lawsuit, it took place on non-Indian owned fee land, even though it's within the boundaries of the reservation, the tribe lacks jurisdiction under US Supreme Court precedent, unless one of two Montana exceptions apply. And so the first Montana exception, and this comes from obviously a case, Montana versus United States, that dealt with non-Indians hunting and fishing on the Crow Reservation in Montana. And the first exception that the court articulated here was to say tribes can't exercise jurisdiction over non-Indians unless there's a consensual relationship between the tribe or a tribal member and that non-Indian. And it gave examples, commercial dealing, contracts, leases, or other arrangements. Importantly, there has to be some sort of nexus or connection between the consensual relationship you're talking about and the lawsuit that's being brought. And it has to be a private consensual relationship. So I'm going to give you two examples to make this a little bit easier. So let's say you're not a tribal member, you're not a member of any federally recognized tribe, and you do go to Mystic Lake Casino, so you're on the Shakopee, Medwakatan Sioux reservation, and you're at the tribal casino, and you get into a dispute with another patron. We're going to say that this is going to stay civil, so maybe it's a dispute about who won a jackpot, right? And you may be fighting about who has the right to money. So, in that circumstance, is there going to be a nexus between the lawsuit that might be brought, right, and the consensual relationship that exists? It's usually easy to find a nexus when there's a contract and the lawsuit is for a breach of contract. So if you have a contract with a tribal member, the contract's being performed within the reservation, the lawsuit against you is for breach of contract, then we would say the tribal court has the authority to hear that. Another thing that comes up pretty commonly would be in the family law context, marriage. So there's a tribal member and a non-Indian, they're married, that's the consensual relationship. And then a divorce action is brought. The divorce action, obviously, there's a close nexus between the divorce action and the marriage, which is the consensual relationship. And so in most of those cases, we would say that the tribal court does have jurisdiction. And that's considered a private, it's not a governmental relationship. So that's an example of how the first Montana exception might apply. The second Montana exception seems a lot broader than it is because of the language, but it has been fairly narrowly interpreted by the US Supreme Court. But the court said that the tribe retains power to exercise jurisdiction over non-Indians if the conduct threatens or has a direct effect on the political integrity, economic security, or health or welfare of the tribe. So it sounds like this is really broad, like police powers, but it's been interpreted more narrowly by the US Supreme Court and by lower federal courts. There are several examples that I can give you of when this exception does apply. One example involved the Meskwaki tribe in Iowa, and this comes out of the Eighth Circuit, which is why I'm mentioning it. But there was a dispute about who the proper leaders of the Meskwaki tribe were following an election. And one of the factions hired a non-Indian contractor to basically come in and take over the governmental building from the other faction. And the court said here the tribe clearly had jurisdiction to hear a court case involving them because this did affect the political integrity. I mean, we're talking about basically an armed takeover of the government building. It looks like there's a question, what happens when a case could be brought in tribal or state court? And so this is when we start to get into the very complicated questions. So you say to yourself, okay, it could be, to figure that out, right, we'd have to go through the analysis we're going through right here, and we'd have to decide that the tribe has jurisdiction. And then we'd have to figure out, does the state also have jurisdiction? We'll walk through that analysis in a little bit. If both the tribe and the state have jurisdiction, I think a good way to think about this is the same way you would think about what if the state and the federal court have jurisdiction? What if state courts and federal courts have jurisdiction? There are no real hard, fast rules here. We often think about, so the question here says, which court hears it? Is it first filed? There is no first filed rule that is going to apply. Both jurisdictions have concurrent jurisdiction. They can both hear the case. What's even stranger than the federal court context is there is not automatic full faith and credit between between state courts and tribal courts. So normally what would happen in a race between state courts and federal courts, if they're both going to hear the same dispute, whichever one decides the case first, then would be binding, right? Because you'd have to give full faith and credit to the other court's judgment. And so the first one would be would be binding. That's not necessarily true when it comes to states and tribal courts. The state, there are rules now that the Minnesota Supreme Court has adopted, Rule 11, that talks about when tribal court judgments should be given full force and effect in state court. It's a type of comedy rule. It doesn't go as far as full faith and credit. And that obviously doesn't bind tribes in the reverse. So it's something that you have to look at very carefully, is under Minnesota law and then under the particular tribe's law, will they recognize the other jurisdiction's judgment? What do I think the proper way of doing this would be? And there are a lot of states that have created, a framework where if both courts really do have jurisdiction, then it is a waste of judicial resources to have both courts hear the case. And the better approach would be for both judges to confer, and for the judges to confer with the parties, obviously, and get their position about which case is the best forum to hear the dispute. And you can imagine that you are going to want to consider a lot of the things that you would consider in in a dispute. If you have multiple state courts that could hear the case, or state court or federal court, what is the most convenient forum for the witnesses? Where are the assets? If there are assets involved in the court case, where are their assets? Which court has the greatest familiarity? Which court's law would apply? So what regulation would apply? But there's no real easy answer to which court should exercise jurisdiction, and it really does require a lot of cooperation. And you can see it commonly come up then in cases where there are non-Indians as defendants in a tribal court action, and it's based on the consensual relationship prong. The one thing I will say is the a lot of these consensual relationships, I mean, other than we're talking about marriage, we usually are not going to have, it is possible to have a prenuptial agreement that specifies, right, a choice of forum. It's just not something that you normally see the parties negotiating ahead of time where the court case is going to be heard. But in a straightforward business contract, if you want to either select tribal court forum or state court forum, provided that it has jurisdiction, right, you can do that in your contract, and it's likely that both jurisdictions would enforce that. In terms of other examples of the second Montana exception, there was a very recent U.S. Supreme Court case, United States versus Cooley, that came out about a year ago, that made it clear that tribal police, for example, can temporarily detain and search non-Indians on the reservation under the second Montana exception. Even though they wouldn't have criminal jurisdiction, they can detain and search and then turn them over to federal or state authorities because of the impact that could have if they could not exercise that authority on the health or welfare of the tribe. So an interesting, before I move off of this piece, so when, in the media has it come up, what jurisdiction do tribes have over non-Indians in a regulatory or an adjudicatory capacity? Think of all of the COVID regulations that have been that have been out there over the past 2+ years, right? There's a lot of discussion about whether tribal COVID regulations would apply within reservation boundaries and to whom, right? And from this brief bit, yes to tribal members always. And when it comes to non-Indians, then the question would probably be under this second Montana exception. The health, or does the conduct we're talking about have some direct effect on the health or welfare of the tribe? And you could see the tribes had a strong argument that their tribal laws should apply within reservation boundaries, particularly if they were requesting something that was more stringent than what perhaps the states was requesting. So what was happening in South Dakota, for example, in the dispute that tribes were having with the governor of South Dakota, tribes wanted more stringent COVID requirements to apply on the reservation. So if you're part of any of this, the facts obviously really matter. How many hospitals, if any, are located on the reservation? What's their capacity with respect to ventilators? How many non-Indians live on the reservation or pass through the reservation? What are the state's corresponding regulations? All of these can be important things to try to figure out when you're trying to determine whether the tribe's law is going to apply to non-Indians within reservation boundaries. What if the defendant is not Indian, but the activity takes place on Indian-owned land, like a tribal member-owned fee parcel or on trust land? This is not as settled as it should be. The whole line of Montana cases, and there are many cases that sort of flushed out those two exceptions in the U.S. Supreme Court. It all started with land that was held by non-Indians in fee simple within reservation boundaries. That's the Montana case. And then that was expanded to rights of way, like state highways and straight versus A1 contractors. And the sort of live or outstanding issue is, to what extent is the same rule going to apply on trust lands? There is a strong argument that tribes can and do make in litigation that they have a right to exclude non-Indians from their own lands and from trust lands. And so they have a right to condition your entrance onto tribal lands on acceptance of tribal court jurisdiction or tribal regulatory authority. And at least in some cases, the U.S. Supreme Court has accepted that and has said tribes have enhanced authority over land that they own or that the United States holds in trust for them. So there is that other category, non-member Indians. So these are people that are citizens of federally recognized tribes, but they are not a citizen of the particular tribe whose reservation they're on, right? Who they're facing a lawsuit, or the tribe that is trying to regulate their behavior. For the most part, the U.S. Supreme Court has used non-member and non-Indian interchangeably in their court decisions. And that makes some sense, as I've indicated on the slide, but the court has never directly addressed this issue when it comes to the scope of tribal jurisdiction. And Congress has at least disagreed and said that tribes have more authority over non-member Indians for criminal jurisdiction. So we're not exactly sure how this would shake out. An interesting question in Minnesota, I think, continues to be to involve the Minnesota Chippewa tribe bans. The Minnesota Chippewa tribe itself is a federally recognized tribe. It's a tribe that you would, if you look on the Federal Register of Lists, annual lists of federally recognized tribes, the MCT is listed as a federally recognized tribe, and it has a federally approved constitution. And so for purposes of determining whether someone's a member Indian or not, there is one criteria for citizenship within the Minnesota Chippewa tribe, and that's found in the MCT Constitution. And it requires a certain blood quantum from Minnesota Chippewa tribe bands. I think that as a result that the proper way to view this is a member of any of the constituent bands is considered a member Indian when on the other bands reservations. So if you're a Leech Lake member and you're on the Mille Lacs Band reservation, you should be considered a member Indian. If you're a Mille Lacs Band member and you're on the Bois Forte reservation, you should be considered a member Indian. But Minnesota state courts haven't always taken that position, and that's an interesting sort of open issue. So I have some summary charts in here, and I'll make the PowerPoint available if it's something that you're interested in, that just kind of summarize what we walk through. So the basic takeaway I think you can get from tribal jurisdiction is we look at the identity of the defendant. If the defendant is a tribal member, the tribe definitely has jurisdiction. If the defendant is a non-Indian, then the tribe usually does not have jurisdiction unless it either the activity takes place on trust land or on tribally owned land, or one of the two exceptions that we talked about applies, the consensual relationship exception or the public health, safety, welfare exception. Okay, so state civil regulatory jurisdiction. So now we're going to see how this gets complicated. And one of the reasons why it is so complicated is we'll often find that the state has authority over non-Indians within reservation boundaries, and the tribe has authority over tribal members. And a lot of regulatory systems aren't really set up that way. When we think about zoning, for example, it would be very helpful for one government to be able to apply its zoning laws within reservation boundaries. But what the Supreme Court has done with this field of federal Indian law usually doesn't enable that. The state usually has jurisdiction over non-Indians and not over tribal members, and the tribe we've seen is the opposite. So again, I'm just going to state out here, Public Law 280 has nothing to do with what we're talking about right now because it's state civil regulatory jurisdiction. Public Law 280 is about court cases, and it expands the state's ability to hear court cases that involve tribal members. Unlike for tribal jurisdiction, we don't care about who owns the land within reservation boundaries for state civil regulatory jurisdiction. So at least we can take that piece out of the equation. Instead, we do have a division between taxation and then other types of civil regulatory jurisdiction. When it comes to taxation, the case law gives you a per se rule. It says states cannot tax tribal members within reservation boundaries unless Congress has permitted it in unmistakably clear language. So unless Congress has authorized the state tax, which it rarely does, states can't tax tribal members within Indian country. For other regulation, a state might be able to apply its regulatory law to a tribal member within reservation boundaries, but only in exceptional circumstances. And this is narrowly defined. It's when really you might be applying the law to a tribal member or a tribe, but your real target is a non-Indian. And then you have to go through this pretty elaborate preemption balancing test that we'll talk about in a moment to figure out if the state has jurisdiction. Most of the case law, I mean, for the most part, case law says states are not going to exercise civil regulatory jurisdiction over tribal members within Indian country. And so the fight really is over, is state going to exercise that jurisdiction over non-Indians? And a lot of the litigation has been about taxation. And we're trying to save money here in Hennepin County, so frequently the lights go off in my office if I don't move around. But apparently, maybe they're gonna stay off right now. So for regulatory jurisdiction over states' ability to regulate non-Indians within Indian country, we usually use one of two tests. One test is the infringement test, which says state law is not going to apply if it would infringe on the right of reservation Indians to make their own laws and be ruled by them. And so that's one test, and it comes out of Williams versus Lee and White Mountain Apache versus Bracker, two US Supreme Court cases. The one that's more commonly used for regulatory jurisdiction is this preemption balancing test. And so what is it in particular? The test says state law will apply to non-Indians within reservation boundaries unless federal and tribal interests outweigh the state's interests. So in other words, if there's a tie, the state gets to apply its regulatory scheme to non-Indians within reservation boundaries. It's not every federal interest or every tribal interest or every state interest that matters. The cases really flesh out what in particular matters. What's interesting here is this is not straightforward federal preemption. Oftentimes the interests we're looking at are not statutes, and they so we wouldn't normally have federal preemption, but they're interests instead. So that's why I think it's better approach to call it a balancing test. What's common is to see states not being able to regulate non-Indian conduct within the reservation if the conduct we're talking about, if there's value generated on the reservation, if it's about not marketing, for example, a tax advantage over the state, and instead it's about resources on the reservation. So the tribe is marketing timber or wildlife or its gaming facility or something along those lines. So a famous case, White Mountain Apache versus Bracker, which established this, was about a tribal timber operation on the White Mountain Apache reservation, and there was a non-Indian business that was helping cut down trees and then cut them up, right, for shipment elsewhere. And the U.S. Supreme Court said that the state was not able to apply its regulations and its taxes in particular to that non-Indian operation because the federal and tribal interests outweighed the state's interest in applying its tax. So you can see whether the state's law applies here. We've got a balancing test. It's going to be very difficult to determine this unless it fits neatly within one of the cases that have already been litigated. And it doesn't give you a lot of clarity if you're the government and you're trying to figure out what rules apply. State interests that matter, in particular, a lot of these cases are about taxation. So the state doesn't have its general interest in raising revenue is not going to be good enough. It has to show that there are some services or functions that are tied to the tax that they're trying to collect, and that enables them to collect the tax. So I've got this chart here. Again, I'll make it available so you can figure out if the state has jurisdiction. I want to give you this taxation example just so you understand this piece that I wrote down here. Why is it that tribes can't support their self-government activities solely, and then I should have put in there, solely through taxes? So if we think of, federal or state governments, for the most part, they're not engaged in industry as their means to support governmental operations, right? The state of Minnesota isn't out there, with a department store or a timber company or a gaming operation as most of its revenue to be able to support police, legislative functions, et cetera. It uses an income tax, and local governments use sales tax and property tax. So this will give you an idea of why that doesn't work for tribes, because when we're talking about tax, we ask where the legal incidence of the tax falls. Where? So is it inside Indian country or outside Indian country? And then on who does it fall? Is it on a tribal member or is it on non-Indian? If the tribe can always tax its own members, and that's true even if its own members are off the reservation, and that fits the rules that we just talked about. But the tribe is unlikely to be able to tax non-members, including non-Indians, unless the tax is taking place on tribal land. And that's because, remember, if it's on non-Indian owned land, we have to fit one of the Montana exceptions, like a consensual relationship. So when it comes to tribal taxes, what does that mean? The tribe can tax non-Indians. For example, if the tribe owns a gas station and the tribe is selling gasoline to a non-Indian, the tribe could impose a tax there. The problem that we see with it is if the tribe is going to impose a tax, the state probably can impose a tax as well too. And so those goods are not going to be profitable or marketable really to anybody if they're price sensitive at all. Because when it comes to state taxation, remember, the state can't tax a tribal member within Indian country unless Congress has authorized it. But the state is able to tax a non-member as long as the tribal and federal interests don't outweigh the state's interests in collecting that tax. So if the tribe wants to tax non-members or non-Indians within Indian country, it often finds itself as the third sovereign taxing that activity, which might make its goods or services just not something that will appeal to the public. So oftentimes the tribe is in a position where it is not able to tax anybody except for tribal members, which doesn't is not going to result in the income needed to operate the government. And that's why you'll see tribes operating businesses like gaming operations. Okay, so I'm still doing good on time. So now civil adjudicatory jurisdiction. We're talking about court cases. This is finally the place where Public Law 280 applies. But here's a big caveat. It doesn't apply to lawsuits against tribes. It's just about lawsuits against individual tribal members. First, I'm going to tell you what the rules are in non-PL 280 jurisdictions, which are most of the country. And then I'll talk about how Public Law 280 changed that. So in most of the country, they use this framework that was first developed in a famous US Supreme Court case from the late 1950s called Williams versus Lee. And there was a Navajo couple that bought goods at a trading post on the Navajo reservation. It was owned by a non-Indian. And they were buying goods on credit, and the non-Indian brought a lawsuit against them in Arizona state court and said, hey, you owe me money, right? And was it proper for the state court to hear that case where the defendants in the case were going to be two Navajo tribal members and the transaction took place on the Navajo reservation? And the US Supreme Court said no, that the state should not hear cases like that if it would infringe on the right of reservation Indians to make their own laws and be ruled by them. So this is the infringement test I mentioned. Now, you might say, how does it infringe to make their own laws? We're just talking about the court case. Well, when it comes to states and federal courts, we often decouple the court that hears it from the choice of law, right? Choice of form and choice of law are usually two separate things. But in Indian law, for whatever reason, state courts almost never apply tribal law. If the state court's going to hear it, they're going to apply state law. And it might just be because state courts aren't comfortable figuring out what tribal law is or interpreting tribal law. And so usually if you're going to say that state court is going to exercise jurisdiction, it would displace tribal law. And that's why the Supreme Court said in Williams versus Lee, no, basically. In the civil adjudicatory context, if a non-Indian is suing a tribal member, the state is usually not going to have jurisdiction because it would interfere with the right of the tribe to make their own laws and for tribal members to be governed by them. The court, not surprisingly, in this case called Fisher versus District Court, said that's definitely true if there are only tribal members involved in the lawsuit. So if the plaintiff is a tribal member and the defendant's a tribal member, the test is at least as stringent as Williams, and so the state's probably not going to have jurisdiction. But in dicta, these cases said, if the tribal member is the one that chooses the state forum, then that's okay. So if a tribal member is suing a non-Indian, for activity that occurred on the reservation, the U.S. Supreme Court said that's fine. They can sue in state court. Because as you can see there from the dicta, suit by Indians against outsiders in state courts have been sanctioned. The court is focused, as you can tell here, on who the defendant is. If the defendant's a tribal member, it should be in tribal court. If the defendant is a non-Indian, the court has decided in both cases that state court is an appropriate forum. So how does PL 280 change this, and what is PL 280? Public Law 280 was a federal statute passed in the early 1950s as part of the US government's campaign to terminate Indian tribes. This was supposed to be an intermediate step towards terminating tribal sovereignty, and obviously that program was eventually abandoned, and by 1970 the federal government was now supporting tribal sovereignty, but Public Law 280 remains. And it enumerated certain states and gave them additional authority in Indian country, and Minnesota was one of them. And so on all the reservations other than the Red Lake Reservation, Minnesota state courts have additional authority to hear cases under Public Law 280. So remember, these are cases now that are going to be brought against tribal members or non-member Indians, not against tribes themselves. Public Law 280 doesn't give jurisdiction over tribes. And this is not about civil regulatory jurisdiction. It's just about court cases. And so as a result, Liz mentioned in that earlier question, what if both the tribe and the state have jurisdiction? You can now see the answer in Minnesota on reservations other than Red Lake. For the most part, is going to be yes, there are two sovereigns that are going to have jurisdiction, because Public Law 280 gives the state jurisdiction over civil court cases. It doesn't answer the question, though, of what is the most appropriate forum to move forward with that. And that can really only occur through cooperation with the courts. So question here is, why is Red Lake different? Red Lake was asked for an exemption from Congress, and Congress actually granted the exception in Public Law 280. So in the federal statute itself, Red Lake is accepted out of Public Law 280, and that's why it is different. And the Red Lakers, if there are any Red Lakers on this Zoom, they will probably give you a bunch of other reasons why Red Lake is different. Red Lake, because of its unique history, the reservation was also largely able to stay intact and does not have the checkerboarding fee and trust land ownership pattern that you see in the other Minnesota Chippewa tribes reservations. So it's mostly a contiguous block of trust lands. I'm not sure that really impacted Congress, but there was specific lobbying to exempt Red Lake from the terms of Public Law 280. Okay, so the last piece I want to cover before we leave time for questions is, well, what about the federal? What about the federal government? First of all, if we're talking about adjudicatory authority, you're going to be comforted here by the fact that it's the same rules that federal courts, if they have jurisdiction, they still will have jurisdiction. There are a couple twists in Indian law, right? So federal courts, we usually look at diversity jurisdiction or federal question jurisdiction. The twist here for diversity jurisdiction is that you cannot sue a tribe in federal court under diversity jurisdiction. An Indian tribe itself as a sovereign is not considered a state for the purposes of diversity jurisdiction, and their mere presence in the lawsuit destroys diversity jurisdiction. So you can't sue a tribe and be under diversity jurisdiction. Tribal members are not considered citizens of the tribe for diversity jurisdiction. They're considered citizens of the state where they reside. So a Mille Lacs Band member who lives on the Mille Lacs Band reservation would be considered a Minnesota state resident for the purposes of federal diversity jurisdiction. And then all the other diversity rules that would still apply. So federal questions, obviously, in the same framework that you're familiar with outside of Indian law. Usually this is going to be part of your well-pleaded complaint. It can't be just raised as a defense. you see federal question jurisdiction a lot when it comes to the area of federal Indian law, because there are a lot of federal statutes and treaties, right, that can support causes of action in federal court. So it's very common to see lawsuits in federal court. A big issue, though, is federal regulatory jurisdiction. So to what extent does a law that Congress passes apply to tribes or tribal members? There are two types of statutes you might think of. A statute that's exclusively about Indian tribes or Indian country or tribal members, and I call those Indian specific statutes. So passing something like Public Law 280, which explicitly is about the jurisdiction that state governments have in civil court cases involving tribal members. That would be an Indian specific statute. But the Congress obviously enacts a whole host of laws that are not Indian specific. These are what I'm going to refer to as general federal laws, like OSHA, National Labor Relations Act, Family Medical Leave Act, Fair Labor Standards Act, etc. And so the big question is usually, to what extent do those statutes apply to tribes or to tribal members? So first, Indian specific statutes are usually easy because we know that Congress meant for them to apply to Indians because they're about Indians or Indian tribes. And so when we're evaluating whether they do apply, the only question we're usually asking is, did Congress have the power to pass that statute? The US Supreme Court has decided that Congress has plenary or general power over Indian affairs. And so really the only question is whether the statute can be challenged under equal protection or under one of the other provisions of the Bill of Rights. For general federal statutes, there are two big issues, really. If Congress was specific about whether the statute should or should not apply to tribes, then that's the end of the story. It will or will not apply based on what Congress said. The problem is that Congress was silent for many statutes it passed, and now we're trying to figure out, does it apply to tribes? And what do we do if the statute has specific provisions or exemptions for state governments and local governments, and then is silent as to whether it applies to tribes? What do you do here? So the way to generally analyze this is to try to figure out, is the statute, this general statute, is it applying to tribal members as citizens of the United States, or is it applying to tribes? So there's a myth out there, right, that tribal members don't pay taxes. As you could see from the earlier discussion, they sometimes end up paying 3 taxes. They certainly pay federal taxes. When it comes to general federal statutes like income tax rules, it's going to apply to the extent that it applies to an individual tribal member, it applies, unless there's an specific exemption. The question is, what about statutes that would apply to a tribe? So does the National Labor Relations Act apply to a tribe that is operating a governmental casino? Does the Fair Labor Standards Act apply to the tribe's conservation officers, right, or the tribe's police officers? So that's the bigger question. And remember, if Congress was specific about it, then we apply the rules that Congress told us. There are some statutes that specifically don't apply to tribes, like the Americans with Disabilities Act, employment discrimination. There are some statutes, and mostly modern statutes, right, that specifically reference tribes and say they're included and they're treated like states, like the Clean Air Act, the Clean Water Act, National Historic Preservation Act. If the statute is silent and it would apply to the tribe, we're going to have to figure out if it would abrogate a treaty right. If it does abrogate a treaty right, then it's not going to apply in this particular case, because there's a separate special test for treaty abrogation. But if it's silent and it doesn't impact treaty right, here in the Eighth Circuit, the question is really, who's asking for the law to apply? Is it a member or a non-member? And that is likely going to drive the result of whether the statute applies, which obviously makes it hard to administer, right? Because there are probably 2 different tests that might apply. But the Eighth Circuit has decided this in more than one case. There was a recent case involving Red Lake's fishery, for example. But the seminal case really is this EEOC versus Fond du Lac Heavy Equipment Company. Statutes such as the Family Medical Leave Act or the Fair Labor Standards Act or statutes like that that are otherwise silent will not apply if the tribe is operating a business and the person seeking for their application to the employment relationship would be a tribal member, right? The courts have said that it does not apply. There are no cases that say it does. There aren't really a bunch of cases in the Eighth Circuit says it does apply for non-Indians, but that sort of is the understanding, although we're not sure exactly what the test is. Okay, so I'm going to stop my share screen, and we have about 10 minutes left. I'm hoping that you all have some questions for me. I guess while I'm waiting to see if there are other questions, one of the other things that you might want to think about in civil jurisdiction has come up on a lot of CLEs is a lot of practitioners are thinking about bringing a lawsuit, and they're thinking about bringing a lawsuit, for example, against a tribe. Just remember, tribes are sovereigns. And so they are going to have, in addition to the jurisdictional rules that we just went over, you have to realize, for example, that Public Law 280 does not enable you to sue a tribe in state court, right? You have to have another mechanism for why the state court would have jurisdiction or why the federal court would have jurisdiction. But in addition to that, the tribe as a sovereign is going to have sovereign immunity. And so you would have to find a waiver of sovereign immunity either in federal law or in tribal law to enable you to bring the lawsuit that you're looking for. Or you would have to bring the lawsuit under the ex parte Young exception. So naming a particular tribal official, arguing that they're violating federal law. That exception applies to tribal officials as well, too. And there's a famous case, Santa Clara Pueblo versus Martinez, the U.S. Supreme Court decided that applies that ex parte Young exception to tribal officials. Yeah, so the question is, yeah, it's not quite on topic, but I'm happy to answer any questions on Indian law. This is about, is there a way for land to be held in trust to be transferred into land owned entirely by the tribe without restriction? And the answer to that is yes. Generally, the advantage of trust land, and the reason, one of the big advantages is that it can't be transferred. But certainly Congress does pass legislation from time to time that specifically authorizes the transfer of trust land from trust into fee for particular parcels. That happens, and then there are also some other statutory mechanisms. It's obviously not the easiest. It's never going to be the quickest process because the whole point of trust land is to prevent it from being alienated, but it is possible. So the question is, I said sort of almost offhandedly, the tribes have jurisdiction to impose taxes on tribal members off the reservation. Could White Earth impose a gasoline tax on fuel purchased and used in California by a White Earth member? Or could the Lower Sioux community impose an income tax on off-reservation income earned by a community member who's never lived on the reservation? Is there any case law that discusses the issue? So the case law, basically says tribes have sovereignty over their members and their territory. That's kind of the famous phrasing that you see in a number of Supreme Court cases, like U.S. versus Massery. It doesn't mean that tribes always have extraterritorial sovereignty over tribal members. So in every case, can I say, no, in every case, is it possible for a tribe to exercise that type of jurisdiction? I'd say first, you'd want to look to the tribal constitution and the tribal code to see if it's attempting. I don't know of any tribes that attempt to apply their tax outside of reservation boundaries, but certainly there are tribes, usually in accordance with treaty rights, but there are tribes that apply hunting and fishing regulations to tribal members outside reservation boundaries. Income tax is always a little bit curious and complicated because on the state law side of things, right, the state is going to consider there to be two potentially taxable locations: the place you're domiciled and the place where you're earning your money. So states end up taxing tribal members if they either work off the reservation or live off the reservation. That is, for tribal members to not pay state income tax, they must both live on their own reservation and work on their own reservation. And so, tribes presumably at a minimum could apply that same rule if the tribal member either lived or worked on the reservation. The tribe could impose an income tax. There are very few tribes that have, I think there are maybe one or two that I can think of that have any sort of income tax, just because tribal members in most cases end up paying federal and state income tax, and it would be a third income tax on top of it. And at some point, you just can't get any more money out of folks. So it's just not something to see something like that, you really have to go down to like the Navajo Nation, which has a fairly massive reservation that spans more than one state. There are a number of tribal members that live and work on the reservation. So they live on the reservation and they work for the Navajo Nation. And so as a result, they're not paying state income tax. And then that sort of enables the tribe to be able to impose its own income tax without really overtaxing its citizenship. But so I think largely you don't see cases on that point, Mr. Pedersen, because it's just something that tribes aren't actually exercising when it comes to taxation, even though they might have the authority to under certain circumstances. Okay, we still have a couple more minutes if anybody else has any questions. Okay, well, thank you for having me present here today. And certainly if you have any questions, you can feel free to reach out to my court address, and I'll make sure that I make the PowerPoint available for the attendees.